Welcome to our continuing coverage, live coverage of the fallout, the impact, the consequences of the amendments, the historic amendments to the India-Mauritius DTAA that was sealed yesterday, sealed, signed and delivered. No miss or no distance between the cup and the lip this time, not even a small one. We are finally there at the Rubicon. In fact, we crossed the Rubicon, and now all that we are waiting for, apart from the government press release, is a copy of the protocol, so that Gautam bhai can literally have split every word, every comma, and every space. But we are joined by three top tax experts. We had Mukesh bhai and PVS sir a few minutes ago. Now we have Dinesh Kanabar of Dhruva Advisors, Gautam Doshi from Reliance Group, and Vipul Zaveri, tax head of Deloitte India, and my colleague Amay Kunte. He's joining us from Seoul. Yes, it's almost 9:30 in Seoul, South Korea. He's there for the IFA conference. He'll be joining in. Probably he'll give some tidbits from there as well. I'll start quickly with a reaction from a quick reaction, a 1-minute reaction from the three of you. Dinesh bhai, probably all of us are surprised that none of y'all are surprised by this. You know, all of you seem to be welcoming these amendments. So, are we missing something here? Shouldn't you all be disappointed?
Last week, I was in Singapore and talking to a number of people out there, and the question at the top of the mind, everybody there, even at that time, was that when is it that India will sign an LOB or whatever else for the Mauritius Treaty? There was obviously an expectation maybe that if there was an LOB, there would not be taxation of capital gains at all, and that would continue for times to come. That said, an expectation to the change in the treaty was there in the air. The pleasant surprise is it has happened sufficiently in advance, giving people time up to the end of the year to plan their affairs, number one. There is a grandfathering, which of course is very, very welcome. And while capital gains will now be taxed, there are enough and more mitigants, and the LOB seems also to be something which is not too drastic. So in a sense, there is no disappointment at all, really.
Vipul bhai?
Well, I would think that this is a rather bold move, given that everyone has got so used to taking the Mauritius route for granted, and that exemption is there with the blessings both of the government and the Supreme Court. But I think it augurs really well. While it is a bold move, it is in line with what the BEPS and the GAAR kind of environment that will come about. And therefore, the most important thing that it does is it gives certainty to the investors coming into India, and therefore I would think it's a bold but a welcome move.
Gautam bhai, was it inevitable?
It was inevitable, and therefore the whole real issue is, as Dinesh said, it's good that it is coming in bits and phases. The fact that you have 1 year before it really kicks in, after that you have a transition phase, which may or may not be very useful, but it is there. And then of course you have the final phase when you will start virtually ignoring the treaty, because on capital gains it will have no impact. It will continue to have impact for other matters, like most other treaties. So something like this, as you rightly said, which was inevitable, so astutely and maturely put from a government which otherwise by and large has been forcing things virtually overnight, for once to have the patience to do it in a scheduled manner is something really good. And therefore, if you were in any case going to accept it, you are happy that it is happening in one of the best ways possible.
Well, if I would just add to what Gautam bhai mentioned, just think of a last time when the government gave something a year in advance. So inevitably, otherwise one would have expected that if GAAR is kicking in from 1st April 17, something may come around mid-March saying this is how we'll deal with the Mauritius Treaty. This is sort of absolutely uncharacteristic of how government approaches a matter.
Isn't that a bit uncharitable, Dinesh bhai, to the government? GAAR is now 5 years in the coming.
Yeah, but that's a separate issue where it is there. The rules are not yet announced in the public domain. We are waiting as to what they would be, what are the safeguards they will provide.
Yeah.
And of course, the impact of GAAR itself, why LOB remains to be seen.
Perfect. Amir, what are the unanswered questions that we are looking at? I'm sure there are several dozen.
Yeah, Arun, very interesting fact which our friend from Mauritius told. First of all, the context of the Mauritius Treaty, it was signed in 1983 when Indian economy was not open, and the capital gain clause was by accident. It was not by design. And now we are sort of correcting it after over 30 years. There are actually, few interesting points that come up, and I would like to ask first to Dinesh. It's relevant in the context of Singapore and Mauritius. There is an immediate comparison being drawn vis-a-vis a Singapore treaty. Number one. Number two, GAAR versus this LOB clause, what overrides? And we still don't have a explicit provision in domestic law to say that where LOB is satisfied, GAAR will not apply. And this question therefore leads to the point around P notes as well, which is a very sensitive issue both from Mauritius and Singapore point of view. So Dinesh, any thoughts on how this does this impact Singapore treaty in any way?
So two parts to that. First, on the India-Singapore and the comparison. First, the provision in the India-Singapore treaty says that India-Singapore protocol clauses 1, 2, 4 and 5 will prevail only so long as there is exemption of capital gains tax under India-Mauritius treaty. Meaning come 1st April 17 and come the introduction of 50% taxation and the exemption going away, ipso facto the protocol does not apply at all. That's item number one. But in a sense, maybe that's just really idle speculation, because we have heard the Finance Secretary Shaktikanta Das come and repeatedly say that India is renegotiating India-Singapore treaty. I'm sure Singapore would want the 50% transition provision. It would want grandfathering, because under the current protocol there is no grandfathering, etc. Singapore might also want a reduction of the $200,000 cap consistent with $40,000, which is prescribed under India-Mauritius treaty. So that has already been announced. Those negotiations will happen sooner rather than later, and therefore I don't think there is any need to speculate at this stage which is good and which is not so good. I think if at all there is to be a speculation, the speculation should be, is Netherlands may be a better solution than both Singapore and Mauritius, and I'm not saying it is, but I'm saying if at all something is warranted, that is warranted. Your second question, sorry, what was that, Amit?
Second question.
On the GAAR versus, yeah. So again, I don't see any ambiguity there. The law as it stands is quite categorical. It says that GAAR overrides the provisions of tax treaty, meaning that notwithstanding compliance with the LOB provision, GAAR will have impact, and if the GAAR provides a larger threshold than LOB, that in accordance with the law as it stands will apply. Now, if you remember, the SHOAM committee, when it gave its recommendations to the government, it categorically mentioned that where there are specific anti-avoidance regulations, those should not get impacted, those should be treated as enough, sufficient, and GAAR should not apply to that. Now, will the government accept it? I hope it does, because if it does not, so for example, under the proposed protocol or the government release of the proposed protocol, you have to meet the business purpose test under the India-Mauritius tax treaty. Now, what will be that business purpose test, and if you satisfy, will the abuse of law continue to sort of apply under the Indian GAAR? We don't know. And I do hope that in the spirit of how government is rolling out each of these amendments, there is a specific provision to say that LOB compliance will be deemed to be sufficient compliance with GAAR.
Yeah, very interesting, because PVS took exactly the contrarian stand, saying that he would think that LOB would probably prevail over GAAR. But still, Vipul bhai, on the point of, this is what you said yesterday, it is a significant tax development and will have a major impact for numerous institutional funds, asset managers and private companies which have used Mauritius route to invest into India. Could you elaborate? You must have been talking to several dozens or hundreds of your clients who operate out of Mauritius. You probably would have talked to your counterparts in Mauritius, Deloitte Mauritius. What are you picking up from them? What did you tell them, and what have you heard back from them?
Yeah, before I say that, just a side comment on what Dinesh Bhai said with regard to the first part of his of the question on Singapore. I have been wondering whether really the Singapore exemption would go away after 1st April 17, for the simple reason that the treaty says that where any kind of any exemption is available to in Mauritius for capital gain, then the Singapore resident will continue to get. Now, for all investments prior to April 17, that is a exemption which will continue to be available. So it's not as if there is no exemption that is going to be available to a Mauritian resident at all. And therefore, arguably, unless the protocol says something differently, or unless the Singapore renegotiated treaty also says something very categorically, would it not be arguable that there is an exemption which is continuing to be available to a Mauritian resident, and therefore the benefit of the Singapore protocol should continue?
Yeah.
So that's just maybe a comment. I would also be interested in knowing what Gautam Bhai has to say, in addition to, of course, Dinesh Bhai. Both are highly knowledgeable in this, so it would be good to know their views on this. But coming back to your question to me on impact to institutional investors, certainly there will be an impact. In fact, since the Mauritius controversy has gone to a different level, the investments coming into India from Mauritius has gradually come down, particularly the portfolio investments. There used to be a high of, in 30-40% of the portfolio investments coming into India were from Mauritius. It has gone down to 25%. So already the risk factor has been, recognized. And now, of course, possibly I don't see much more correction on that, but yet it may have an immediate impact. The bigger, of course, impact will be on the traders or the P notes and the hedge funds, and therefore the investments made by them would certainly be now subject to a much higher capital gain tax post April 17, and therefore certainly it would have a negative impact on the market. No one is happy about that, of course, but that's the way life is.
Yeah. Amey, you want to put a question to Gautam Bhai on the LOB clause, because the LOB clause has come in for some sort of attention scrutiny today on whether it's too widely worded. You had TP Oswald telling us that what is business bona fide, what is conduit company is up in the air. Amey, you want to post to Gautam Bhai?
So just to add to this, on the LOB language. Is it too subjective, and also adding to the principal purpose test that we are talking about under BEPS, does this sort of give enough room to the officers to examine the structures more closely? Even without language, we have in Aditya Birla Nuvo, tax officer actually looking at essentially the business, the main purpose test. Gautam Bhai?
Yeah, I think certainly one would like clearer language. But as of today, it looks like the approach of the government is going to be more reasonable. If one goes by what somebody like Shaktikanta Das was saying, effectively trying to say that while I don't promise and I cannot tell you what the next budget will contain, if you comply with an LOB clause which we are drafting today and which we are giving you, naturally we don't think we would apply GAAR to. So virtually giving a solution saying that GAAR may not apply. The language of LOB, will the department use that as a vehicle to harass, or will that effective test of amount spent take care of it, and all the rest of the language is just language? And then the final test is only really what have you spent, what have you not spent, and spent what, so long as it is on operations. The rest is all irrelevant. The business purpose test is just words and not something which you really have to worry about. The objective test is how much money you have spent. And if that is available, then the LOB should not really be so much of a problem. And perhaps will not even worry GAAR.
Right. Gautam bhai, just a related point. Arun,
Yeah.
is that fine, or you want to take up the question?
Sure, please.
Yeah,
Please.
Gautam bhai, another point, there has been a debate on income classification, particularly for FII stroke FPI investments, whether it is a business income or a capital gain income. And this protocol, is pertaining to the capital gains section, capital gains article. Any thoughts on how this controversy will pan out post the LOB scenario, particularly
Again,
for Mauritius?
sorry, no, you were saying particularly.
Particularly under the India-Mauritius treaty, the FII investments, where there has been a debate on business income versus capital gain classification, and now that this LOB applies to the capital gains article and will not apply to the business income article, is there any sort of impact on this controversy?
Yeah, there should be, but I thought more or less it seems to be settled today that all investments are really capital assets and it's a capital gains clause which will apply and not the business income clause. Now, will it be raked up again to get out of the LOB clause? I think between the risk of trying to rake that up and against that, the cost of complying with LOB, almost anybody would comply with LOB. So it will only be those few who by mistake have not complied with LOB, by oversight have not complied with it, who would then perhaps, for the sake of argue that it is business income and therefore not subject to the LOB. So the possibility in practice of this litigation coming back to the fore, I would think is small, though technically I would agree with you that it will remain as one of the possibilities.
If I could just supplement that question, that answer, there were only two rulings which were sought at the instance of the SSE, where an SSE sought a ruling from the AR arguing that the income is business income and not capital gains. The first was a successful one, and the second one was GE Pension Trust, where the whole thing came totally a copper, and GE Pension Trust was in fact denied the applicability of the tax treaty itself and landed itself into a bigger swoop. And I totally agree with what Gautam bhai is saying. It has not been the case thus far that the department has alleged business income. In fact, now under domestic law, there is a specific provision of FII trading in shares being regarded as income from capital gains or giving rise to capital gains. And therefore, as Gautam bhai said, unless somebody has missed out or is denied for any reason, the tax treaty benefit, somebody might come and argue business income. Otherwise, it's unlikely to happen.
Dinesh, you've been, saying since yesterday, one of the reasons why you welcome this is because you said it gives certainty. But are you confident that post these clarifications and probably a lot of clarity, as you see in the protocol, will we see less litigation on the Mauritius front? Are you confident about lesser litigation?
Arun, it's actually quite an interesting question. All of us, and me very much included in that, dealing with the tax office tends to be very cynical and skeptical of the tax office. And I think maybe it's time that, at least in some of these matters, we get out of that cynicism and skepticism. If one goes by what is the approach thus far, the approach is to say that A, this is capital gain, B, it is grandfathered. So, for example, if one goes by this protocol, even today we have this issue that when you go to get a 195 or a 197 certificate for a sale by Mauritius of Indian shares, it's difficult. Now there ought not to be a challenge at all, because it's categorically confirmed that even post March 17, if an acquisition has happened pre-17, you are grandfathered. And therefore, I would say that while one can be cynical, one can be skeptical whether there will be practical litigation, it ordinarily, law implemented on an even-handed basis ought not to give rise to litigation.
In fact,
People,
yes, what I was saying, Vipul, do you think that at least for 1 year, foreign portfolio investment will in fact grow from Mauritius rather than come down.
No, for the 1 year, of course, it won't really impact, because up to March 17 there is a comfort that the short-term traders will continue to get the benefit, and therefore up to March 17 there should be no problem for them.
I'm wondering whether there will be a positive upsurge, and in particular.
Well, that depends on the market. And what else the government does. So it's hard to predict the market really.
But to just that, Gautam bhai, is it not likely to happen that come 31st March, one will see at least, so like say the last week of March, would people not try to book their unearned gains and push the cost base up?
Yeah, that is one, and I expect that by March, perhaps people may transfer investments held elsewhere to Mauritius if they can, because then they are assuming they believe the grandfathering. Then they are grandfathered.
Absolutely. I would agree with both the points. So, Arun, at one level, if you are coming through Mauritius, you will want to push up the cost base so that the gains until that day are certain and protected. Number one, and if you are elsewhere, you will certainly want to ensure that you come to Mauritius and get that treaty protection.
One just wonders whether one wonders
applicable for FDI rather than portfolio, because portfolio really, it doesn't make sense to move it on the penultimate day of the grandfathering.
Yeah, all of this is quite fascinating to hear, because it takes us back to the Supreme Court hearings in the Vodafone case, the 8 days hearings. And I remember Senior Advocate Aspich and I drawing distinction between Westminster, Ramsay, and I think it was Fisher. And one of those the differentiation was the step theory. So if this is one of the steps to achieving a tax exemption, would you probably get covered under the LOB? Would you probably fall foul of the main purpose test and all of those things? Of course, that's what keeps us going. If you have interesting questions, we'll have a few more hangouts. But I have one question for both Amay and Vipul bhai. Probably the panel as well. Quick answer could do. Do you think in some ways the Panama leaks may have influenced early signing off of the Mauritius Treaty, which has been pending for 12 years? I think it's had a big impact worldwide. The Panama leaks. Do you think that may have some sort of a persuasive impact on the Mauritius government, that the days of tax haven are over, as Richard Murphy has just written yesterday, that the days of tax havens are numbered? If that be the case, better to get away, with escape by cutting your losses, as they say. Vipul bhai?
Yeah, certainly. I think the days of tax havens flourishing are nearing end, with BEPS looming large. And I would even think that Mauritius might itself want to revise their domestic law to also have a capital gain tax, for example, which they have consciously held back, because they also need a certain source of income, and it might be a good idea for them to impose a local tax also.
Perfect. Amay?
Arun, I personally feel maybe it's just a coincidence, because a Panama issue is different than, say, a Mauritius situation, where Mauritius is already complying with the information exchange, particularly with reference to India, the expectations around round tripping and so on. So there is a regular flow of information, and therefore the situation is different in my view. Just one point to Gautam bhai or Dinesh, we were talking about various situations. One unexpected consequence of this could be invocation of MFN clause. Certain other treaties have MFN clause with Indian treaty, and does this create a scope for at least next 2 years to apply the beneficial provisions of India-Mauritius protocol in other treaties? One will have to look at the language, but and it's technical also, but this seems to be possibly an opportunity if such a view exists. Dinesh bhai?
If I could just add to that, Dinesh bhai, I was in Africa for the IBFD conference last week, and Netherlands treaties, recent treaties, including one with Kuwait, has a non-discrimination clause in the bilateral investment treaty. So, will any of the other treaty partners, the bilateral treaties that India has signed, could they also invoke any of these non-discrimination clauses if there is one?
My question was in fact reverse. There is a most favored nation
Yeah,
clause
absolutely.
in the so,
No, clearly, I would agree with you that if India has a treaty where there is an MFN provision, one could take advantage, but that depends on the wordings of each treaty. I must confess that I haven't carried out a study as yet of which are the other treaties which could get impacted as a result of the protocol. I'm sure that one will need to look at it and carry out a research on that.
Gautam bhai?
But no, I would think if MFN was available, the current Mauritius treaty was even better.
Absolutely, absolutely.
So if the protocol is watering it down, how could that really?
Yeah, Gautam bhai, the MFN clause says that if any of the countries enter into agreement after the treaty was entered into force, Mauritius was entered way back in 1983, and most of the MFN clauses have been entered by India in 90s, late 90s, in fact, treaty like France and so on, and therefore possibility whether this can be explored. So anyway, I mean, I think some fine print analysis will give us an answer on this. Arun?
Last word, I think
Is the treaty by itself, or is just an amendment and therefore not subject to the MFN?
Yeah. A quick final word from our three panelists. Vipul bhai, Gautam bhai, Dinesh bhai, in that order. Vipul bhai?
Well, it's really a welcome move. I think certainty is something which all investors, and particularly the FDI investors who would be affected in a big way for the large investments that India is making, India requires today. I think that certainty will help bring clarity to the investors. Whether to use Mauritius or not is a different thing, but the mere fact that that route is available or not available, or at what cost it will be available, I think that clarity is the most important thing that India can give to the global investors. And I think, therefore, this is something which is positive.
Gautam bhai, any larger message that we should read into with the government signing this DTA? It's been 12 years in the making. It wouldn't have been easy to persuade, to convince them to finally sign on the dotted line, the Mauritius government. The fact that India has managed to do it itself is a big achievement. Any larger message that we should read into?
I think, as you rightly said, the background really perhaps mattered to Mauritius, and it is not perhaps the Panama leaks, but BEPS, and the way the world is moving. And that may have been one factor which I am sure must have influenced the Mauritian government, that with the advent of BEPS, how long they will be able to sustain their current position was a question mark. And then it is much better to have a negotiated settlement with a grandfathering clause of this nature, which at least protects everything which has happened till today and for 1 year from today. Is something fantastic. So they may have really agreed to it for that reason.
Yeah. Dinesh bhai, we have 20 seconds left, Dinesh bhai.
Just one comment I would make is that there is a particular issue which has been put with regard to source-based taxation. And I was wondering whether that means that other income would be liable to tax in India as opposed to Mauritius. And if that is so, there are significant impact on how you interpret Section 56 today, how derivatives would get taxed, and a number of other things. I don't think that is something which people have looked at, and that needs to be looked at very, very closely.
Thank you, everyone. Thank you so much, everyone, for your time. Amay, Dinesh bhai, Gautam bhai, Vipul bhai, we are absolutely running out of time. Thanks so much, all the viewers, and so many of you all have joined us for this hangout. Hope there is a little bit more light at the end of this not so dark tunnel, but I hope we are all better off after hearing from the big experts right on the screen. Thank you so much for joining us on this hangout. Thank you.
Thank you.
Thank you. Thanks, everybody.
Thank you.